A very good morning to all of you. A warm welcome on the e-platform of Faculty of Law, GLS University. It is a wonderful day, first day of the month of March, and it is a great event that we are starting with on the very first day of the month. And as it is truly said that something that is narrated in the form of a story, it becomes eternal. It stays forever. With that note, we are starting today's event that is Stories by Warriors of Justice as a part of celebration of 75 years of adoption of Constitution of India. And we started all the events from 26 November 2024, and it would be a year-long celebration. I would like to request our dear Dean of Faculty of Law, GLS University, Dr. Mayuri Pandya, for her welcome address on this occasion. Over to you, ma'am.
या देवी सर्वभूतेषु शक्तिरूपेण संस्थिता नमस्तस्यै 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 namo namah. I bow down to Vidya Shakti, present in one and all, present over here on the e-platform of the Faculty of Law, GLS University. I welcome all of you today. This is the fourth event of the Samvidhan Safar. And if we talk for the Samvidhan Safar, it's a celebration of justice, rights, and the tireless efforts of those who shape the legal landscape of our country. We are celebrating, we are honored to host Stories by Warriors of Justice. This is an event that brings together some of the most influential voices in the legal fraternity. And they are the champions who have not only interpreted the Constitution, but have fearlessly upheld the spirit of the Constitution. We are honored that all these three legal luminaries have accepted our invitation and they are with us today. This is especially for all the students who have joined today, that these three legal luminaries, they have upheld the spirit of the Constitution, and the landmark judgments, the three landmark judgments, which I think as a law teacher or a common person of the country, or as a law student of the country, I don't think that we are unaware. And we are thankful for them that they are with us today. On behalf of the Faculty of Law, GLS University, and on behalf of our president also, Mr. Sudhi Nanavati, who himself is a senior advocate, a renowned advocate practicing at the High Court of Gujarat and the Supreme Court as well. On behalf of everyone, I welcome all three of you today at this e-platform of the Faculty of Law, GLS University. Your contribution is enormous, and especially the three landmark judgments, that is Vishaka versus State of Rajasthan, State of Maharashtra versus Bandhu, and Laxmi versus State of Union of, I forgot the name, the Union of India, Laxmi versus Union of India. All the three landmark judgments. I request all the three legal luminaries to come up with their own story. The object is that we wish you to share your journey, your story, how you could uphold the spirit of the Constitution, what difficulties you faced, and how it has changed your journey as a legal professional. This is what the object is. Once again, on behalf of everyone, I welcome you on this e-platform. And my specially, I want to tell Naina ma'am. Naina ma'am, when 97, I was doing my post-graduation. And at that time in 97, Vishaka versus State of Rajasthan judgment came up. And in my LLM examination, there's in one paper, social transformation, one part was women and law. And in that, in our examination paper, the critical analysis of that judgment, that question, I had written that I answer of that. And from that time, 97, I'm so happy today to welcome you. And we are really thankful to you for accepting our invitation. Uh, Thank you, ma'am. Over to Payal, ma'am.
Thank you so much, Mayuri ma'am. Dr. Mayuri Pandya, the Dean of Faculty of University, is the face of Faculty of Law at GLS University. She is an exceptional academician with the vision to take Faculty of Law further in the field of legal legendary. Now, without taking much time, we would like to share a video to all the dignitaries that is made for today's special event. As ma'am already mentioned, this event has been a special for all of us and especially for the students who are going to watch today the landmark judgments and very interesting judgments that they have studied in the books, in the theory, and they would be listening to it straight from the horse's mouth today. And they are very excited for the same today. Here for all of you the audio video presentation for today's event.
करके दिखा कमाल वो आके ज़मीं पे देख जाए आसमां शाबाशियाँ शाबाशियाँ शाबाशियाँ
Thank you so much for being there with us for today. I would like to request Dr. Jia Mathrani to introduce our esteemed guest for today for the event for our viewers to get better idea about them. Over to you, Dr. Jia Mathrani.
Thank you, Pal ma'am. It is indeed my privilege to introduce Naina Kapur ma'am, Advocate Supreme Court of India. Ma'am is a veteran law and equality consultant with over 30 years of national and international experience in women's and child rights, access to justice, and law reforms. Her expertise spans gender based right, equality compliances, preventive law practices, and research driven capacity building programs. As an independent consultant, she provides expert legal advisory service on workplace sexual harassment, gender audits, equality compliances, and investigations. She co founded Sakshi, an NGO in India, and played a key role in Asia specific advisory forum on judicial education on equality issues, a uniform recognized best practice initiative for judicial education. A key contributor to legal reform following the Nirbhaya case, she was instrumental in shaping India's sexual assault laws. Her landmark litigation include Sakshi versus Union of India, which led to child-friendly courtroom procedures for abuse cases, and Vishaka versus State of Rajasthan, which established binding workplace sexual harassment guidelines. A widely published legal scholar, her work includes Breathing Life into Equality and Empathy, a hallmark of equality, and many more in the list. Her academic credential includes an LLB from King's College, University of London, and fellowship at Harvard School of Law. With a career dedicated to legal advocacy, education, and systematic reforms, Naina Kapur ma'am contributes to influence global discourse on equality, justice, and human rights. Over to our warrior, Naina Kapur ma'am. Ma'am, sorry, you need to unmute yourself.
Yep, I understand that.
Thank
It
you
is
so
done
much.
now. Yes.
Okay. Well, thank you. That was a very, I can't live up to what you just said. Okay. But, anyways, it's a pleasure to be here and to talk to students about what I think was actually a transformational experience, not only for me, but I believe for all women in India at all workplaces. But before I begin, you're showing this photograph of myself and Bhavri Devi. I just wanted to emphasize that's who it is. And the reason I choose this as my profile picture is because the reason Bhavri Devi was a lower caste, illiterate woman living in a very patriarchal society. She, not me, is the central catalyst for a law that you and I now benefit from today. So I'd like to acknowledge that. So to the students who are listening to this, what I'd like to say is you've chosen to do law. Okay. A fundamental question you must ask yourself is why? What is your motivation? Because, and the reason I want you to ask yourself that, because you must always remember that at the end of every law is a beneficiary, the person who you're serving. And at the beginning of every law, though, is an attitude. Be it the law, the lawyer, the judge, or the person, the policymaker, or the legislature, there's always an attitude. So the two don't necessarily connect. For that reason, and given that women were central to my work and my lawyering, my motivation as a lawyer has always been to alter the status quo. I think that is the only role that litigation should play. And I think we would have much less litigation if we really focused on that. Because the goal is to centralize the narrative of the harm within an understanding of equality, at least where I was concerned. What did that mean? First, it meant when we did the Vishaka case to acknowledge the context. At the time of Vishaka, there was a 1.5 century old void in both the law and social conversation, where the word sexual and harassment did not exist. In fact, all things sexual were taboo and sustained by this like terrible aura of discomfort in India. All things sexual always create discomfort. It's what I call the Hall factor. And that's what alienates women from their equality rights and makes it easy for the rest of our society. This is the status quo in which I sought to change through Vishaka, not just me. Associating sex with equality instead of morality. So keeping that in mind, what elements were central to our equality case? Above all else, and if there's one thing I can stress more than anything else, process, process, process. The process you adopt, is it inclusive or not? I want to highlight what are 5 elements of that process here. The first element, in the words of Catherine McKinnon, make law fit life, not the other way around. That means use your imagination. See, everything isn't about what's written in the words of a law. It's about how creative you are with that language. Ask that wonderful question when you have to deal with issues like this. So what if? What if I thought of doing it like this rather than like that, the way everybody else does? Because that is the question which sets the groundwork for creating a quantum leap in equality, especially for marginalized groups. The second element, shape your equality argument from the ground up rather than the top down. That means involve your beneficiaries, know who they are. Our engagement in the Vishaka case was with a very personal, very public narrative of Bhavri Devi. You've seen that photograph. That individual shaped everything for me. She was the strongest person I have ever come across in my life, given what she had undertaken. But she did it out of with pure dedication and belief that women needed to benefit. She became central to how the Vishaka case was shaped. So who was Bhamri Devi? She's a poor woman. She belonged to a lower caste Potter community in a rural village, which was highly conservative. She was married off between the ages of 5 and 8. She had no education. And when she grew up, though, she joined one of the most revolutionary women empowerment programs in India. You must read about it. The Women's Development Program. She was amongst an army of rural women leaders who were exposed to feminist resources and civil society educators for the first time in their lives. Each of these women qualified as a Satan. Satan means friend. And they became village level workers. So their workplace was not an office. It involved them moving from one village to another, where they engaged in helping women improve their social and economic status. In terms of the Satan program, I mean, had Bhamri been working in any other corporate world, she would be considered a star performer. And that's what she was within the program as well. But the downside of innovative programs, especially when it's about women, is the underlying social perception that Hall factor, it might threaten our traditional and cultural practices. We personalize it, and so we resist it as a society. And that's what became apparent on one particular occasion when Bhamri intervened to prevent the child marriage of a 1-year-old, which was taking place in an upper caste community. Her single intervention sparked a hostile workplace, not just for her, but for all Satans and workers in that area. To make matters worse, the local government had already decided they would raid the villages and stop the child marriage. That was a strategy which ran completely contrary to the Satan methodology. Their methodology was persuade, prioritize persuasion over confrontation because you're dealing with a status quo. But that didn't happen. With the police raids, the damage was done. The fallout only aggravated the hostility towards the Satans. Bhamri and her family became the target of an economic and social boycott. There were threats to teach her a lesson, in quotation. It was all within the knowledge of the local police and the administration. They did nothing. They did nothing. And if there's one thing you should remember, omission is akin to commission. The absence of doing something means you allow something else to happen. The result was she was gang raped by 3 upper caste men in the presence of her husband. She went public with her complaint, which was very Bhamri, that's what triggered this historic protest across the country by civil society groups, feminists, and others. But the problem was the instinctive call everybody made was, okay, let's arrest the rapists, which is not what I was ever aligned with. The thing is, it's always been our default response to sexual violence. We'd seen it before. For some of us, including myself, justice ought to ensure individual women should emerge through a legal process with their sense of self intact, not in tatters. The criminal justice system rips apart women's reality and reduces it to nothing. It's not worth it. To that end, the criminal justice system, I think, has consistently failed women. I was called by the groups in Jaipur to be present in her in-camera testimony. They said they couldn't find a single woman lawyer from Delhi to come and do that. So I was at her in-camera testimony in the criminal case. You can read about it in the article that was cited earlier. There were 17 men there, including the rapists, and 2 women, myself and Bhamri. And this was an in-camera hearing. No one wanted to read out her statement or refer to it because of its very detailed, very graphic content. No one wanted to listen to what she had to say. And I wasn't allowed to speak because I was just there as that support person. And I remember it was actually a very devastating experience, because sitting amongst all those men where nobody wanted to listen, and there was this judge who was sitting like a poached egg on the bench, not intervening, saying nothing. At the end of us, both of us really collapsed through that experience because it was so exclusive. There was simply an institutional deafness to her voice, which brings me to the third element of shaping an equality outcome. That includes when you make an equality, if you're looking for an equality petition, facilitate voice and participation of the beneficiary. In our case, that was Bhavri and the Satins. Those are the voices who are the true experts of equality. They are on the receiving end of the hurt, which is why when it came to preparing for our PIL, we gathered in Bhavri's village and engaged with her, 350 Satins, local feminists, and other activists. And we listened. I think that's a factor that's absent in much of the legal profession, the ability to actively listen patiently. It was that lengthy, informed process which helped us connect the dots between constitutional equality and sexual harm. When you listen to people's stories on the ground, they are what fill our constitutional rights. Decentralizing that narrative is what gives meaning to a concept like equality. And that's what inspired the content of our public interest litigation before the Supreme Court of India on behalf of all working women. So when we circulated the draft to the Satins and others for feedback, what we got back was a focus on the Satins' experience of workplace sexual harassment. Remember, it was outdoor. This was not a typical workplace. Their definition of what it constituted. And remarkably, their definition corresponded with international law at the time, with the Convention on the Elimination of Discrimination Against Women and with the Violence Against Women recommendation. So what does that tell us? Process matters. It becomes proof that equality fashioned from the ground up can achieve results which are consistent with the law, make those results meaningful and accessible to a broad range of beneficiaries, and eliminate complex legalese. I mean, this was the hardest part for me as a lawyer in early years. Everybody talks legalese. How will you include a beneficiary when that is the language which we adopt? Again, the stories of harm are the one that need to shape the language that we use. So there's a fourth element of shaping an equality outcome. Ask for the moon. What's the harm? Just ask for the moon. The Vishaka pleading sought three outcomes. First, recognize workplace sexual harassment as an impediment to women's equality and dignity based on the Satins' experience of workplace sexual harassment. Second, given there was no law on workplace sexual harassment in India, we wanted the court to take the Women's Equality Convention, CEDAW, I'm hoping you've all heard of that, and make that directly applicable in Indian law until the vacuum was filled. And third, and this was our ask for the moon plea, persuade the court to direct all workplaces to put in place an innovative structural redress mechanism, which we had crafted within the workplace. It was a big agenda. And all we needed was a fifth element, judicial empathy. At the time of the Vishaka petition, that empathy came in the form of the Chief Justice of India, Justice Verma. In an interview, Justice Verma, post the Vishaka outcome, said he had described himself as a commoner. I think it's a position which he felt gave him a real life ringside perspective on sexual harassment. Verma's empathetic stance is what enabled him to use what he referred to as judicial creativity to produce a quantum leap in equality. Whether we're lawyers, judges, academics, or activists, empathy is central to molding a substantive equality outcome. So what were the equality outcomes? Irrespective of there being no domestic law on workplace sexual harassment in India, The court agreed with us that international conventions weren't just meant to be pie in the sky. In fact, women had a legitimate expectation that these conventions would also apply to them. So they determined that CEDAW would have direct application in Indian law. That was a huge step forward for international law in our domestic context. It was historic and creative. Effectively, it realized the practical realization of the equality principle for all working women. Specifically, the court made it clear that each incident of sexual harassment will constitute a violation of women's right to gender equality at her workplace. Imagine that. Actually, if you go into the specific of women's real life experience, what that meant was something like ogling, which is so systemic in our lives, amounted to a violation of your constitutional right to equality. So with those two building blocks in place, the court was on solid ground to mandate the structural innovation which we had advocated for. Apart from directing all workplaces to prioritize prevention, most significantly, they established this internal redress committee, which we'd asked for. 50% women, a senior woman as a chair, and again, I think, a really critical inclusion, which we had asked for, was the third party expert. This last inclusion, I think, was a quantum leap in equality activism, because it literally mainstreamed the active presence, knowledge, and skills of civil society groups and legal activists into the Indian workplace. This then was the Vishaka model. It wasn't a perfect outcome, but it was bold and it was meaningful. And the impact was far reaching. I think overnight, it transformed women's sexual rights at the workplace into an equality norm. Sex was finally out of the morality closet. Working women were armed with a voice to exercise equality at the workplace. And the accountability had shifted from individual women to the workplace institutions. Above all, it created an institutional alteration in the form of an internal redress committee, opening the door to civil society expertise at all workplaces. But there was an additional bonus. The entire activist-led equality process, I think, transformed Chief Justice Verma into the future face of judicial activism, and that was post Nirbhaya, and all of you would probably be familiar with that. I just want to add one last thing. I think my time is over. That when the decision came, I went back to Bateri and I met Humphrey. I have to say the equation that we had developed over those years were the most meaningful in my life, you know. And when I told her, I mean, it makes me emotional even now, when I told her that it happened, she immediately said she wanted to set up the internal complaints committee at the ground level for the Satis. And we both fell into, I know it sounds really dreamy, but we really did literally fall into a mound of hay, laughed and enjoyed that particular moment with one another. So to be clear, I think know what motivates you to do something like that. Know your beneficiary. You have expertise, but that means nothing if it's not shaped from the ground up. Make the law fit life, think out of the box, and ask for the moon. Thank you.
Thank you so much, ma'am. I'm sure all the viewers, all our students, they are so happy to hear you, and they were just paying attention to all the detail that you were mentioning. There are few questions, ma'am, our students would like to ask you. If you may permit, maybe take a few of them.
Pile ma'am, before student ask, can I ask one question?
Ma'am, please, ma'am, please.
Naina ma'am, after the Vishaka judgment, was there any specific change in your personal professional life?
Totally, absolutely. I have to say, one of the reasons I even did law was because I wanted to benefit the most common denominator, which is who has least access. I traveled around the country, and if I may just add one story, very short one. In the beginning, I traveled around the country. I went into Bihar, Jharkhand, everywhere, into the deep areas. And we would show this film with Zeenat Aman. I can't remember the name, but anyways, the question we asked, Insaf Ka Tarazu, right? Yeah. Are you familiar with that? Somebody say, yes, I am. Okay, it's a Zeenat Aman film. But anyways, we went and showed it to women at the ground level. And after that, we would ask them, what does justice mean to you? All right. Across the board, really, they would always say, it means having my sense of self intact. I want to be whole. I don't want to be in tatters when I go through the justice system, which is the way the justice system functions for most women. And that actually, yes, and with Bhamri, it changed my life because I thought I would only do the, benefit the women who, if I could be a third party, great, I'll benefit the women and shape the perspective of internal committees based on Bhavri's experience. That's it. How would
Yes,
you?
ma'am. As you mentioned,
You want me
the
to read this
question,
out? Oh, go ahead.
yes,
Go
yes.
ahead.
The question is about how would you adapt your legal and psychological strategy if, again, the Vishaka case today, considering the evolving legal and political landscape?
Okay, so let's drop the legal psychological language because it's all about compassion and empathy. I give you another story. I developed a collaborative program between judges and civil society. They had to work in partnership with one another. We work with drama groups, et cetera, to build empathy when it came to people who needed to access justice, who were less able. So it's about building compassion and empathy. It makes no difference what kind of law you have. If you can't see the person on the ground as a whole person who needs not help, but they need you to listen to their narrative. They need you to listen with empathy. And, people will say, oh, then wouldn't that be bias? I think the absence of empathy is bias. So I would say empathy is key to lawyering as well as to judicial decision making. And yeah, there's a lot of that's absent even in our political landscape. It doesn't exist.
Okay, ma'am. The another question is from the other student who wants to ask that workplace harassment laws have undergone significant evolution since the Vishaka judgment. So, do you believe that current legal frameworks sufficiently align with global best practices, or are there areas where India's approach still falls short? Or do you have any suggestion for that, ma'am?
I think India's so far ahead of the game with Vishaka. I think the problem with when you decide to, like when the legislation was happening, honestly, it was crippling. Because again, you have to remember, it goes from the person on the ground, it goes through all of us having this discussion, it goes into, collaborative and negotiation, then it goes to the government, the policymakers, then it goes to this one individual sitting in a little room who's going to be finally writing that piece of legislation with language that has no resonance to the person on the ground where it started. So I remember when the legislation came out, the only thing I insisted on, which was not there because all of it was awful in terms of framings, you have to give meaning to it, was to say, please, at the introduction, what do you call it, which states what this legislation is about, please include CEDAW. Okay, because that then made that the yardstick by which we would then be able to interpret the legislation. And they did. That was the only saving grace for me. Legislatures should keep their hands off. They should really let the rest of us do it, especially because you are so remote from the ground. You're so remote from the reality. And it's filled with assumptions and stereotypes. It's a badly crafted legislation, I would say. And it makes it hard. But We always use the CEDAW overarching umbrella to do the interpretation whenever we use it.
Okay, thank you, ma'am. The last question, with your permission. One of the curious students wants to know about it, that if you were to argue the Vishaka case today, would your legal approach or advocacy strategy differ? If so, how and why?
I would have made judges come and see what our process was when we were preparing this on the ground with Bhamri Devi and 350 satins. I would make them come and see how law or equality outcomes should actually be crafted and understood. Because the judiciary is so removed from the ground reality. If you don't have an experiential understanding of what's happening on the ground, everything is just mental and up here. So yes, I think that would be, I learned that later, and I did it later with judges, making them meet people on the ground. But I wish we had done more of that. But it didn't occur to me then. It didn't occur to me then. But in hindsight, yes, that would be the change. They should be on the ground. They should listen to people. They should watch a process. These were the brightest women I've ever met, satins on the ground, because of their experiential understanding of life. And again, it's about, don't make the law fit life the other way around. Okay?
Thank you, ma'am. This question I think you have already answered, but I have taken up as the student wishes to know that how has the role of lawyers and activists evolved in advocating for women's rights since the Vishaka case, and what challenges remain in ensuring effective implementation of these laws? As you already mentioned about empathy and empathetic approach, I think you have already answered this question, ma'am. But if you wish to add on anything, we would like to hear. This would be the last question for this session.
Okay, so you asked me that question about when legislation gets created, and I always have this picture of this little bureaucrat in a tiny room with his pencil and doing that. But the voice of the beneficiary, the voice of organizations, the voice of civil society, the voice of those who are impacted, you have to carry those with you if you want. It's not about effective implementation of the law. It's about get rid of making new laws. Apply the equality principle. For God's sake, interpret anything you're doing in terms of law through that lens. It's the critical one. So I think lawyers and activists have to learn to work together much more with respect of the experience. Lawyers, activists, and beneficiaries. Whenever you're framing something like that, be inclusive. Don't exclude anybody. They should be part of that. And then you'll have a much more effective outcome. Okay?
Okay, ma'am, thank you so much. And I request you that in future, whenever possible, whenever we invite you, we wish you to be on our campus and you interact with the students personally. So before departing, we want that promise from you that you will in future, at your convenience, of course. We wish that you interact with our students in person in future.
Doctor, I prefer that than doing this because I can't see any of your students. So it's very difficult.
Sure, ma'am, we will invite you. Thank you
you
so much. Thank you so much for sparing your valuable time. Thank you so much.
Thank you.
Ma'am, just a minute, if you can stay, we would formally also would like to thank. Okay.
Okay. Thank you so much, ma'am.
Shirin ma'am?
Yes.
It is
It was a pleasure listening to you, Naina.
Okay,
And it's
Shirin.
been
I
so
think I
long
accidentally
since I
cut
heard
somebody
you.
off. That's when I came back. Nice to see you.
so much, ma'am, for
You're
your
welcome.
insightful address and all the questions that you answered. We are thankful to you for the same, ma'am.
I hope it had some benefit. That's all.
It,
Thank you
it
very much.
certainly has, ma'am.
Okay. Thank you.
Thank you so much, ma'am. I request Dr. Jia Mathrani to introduce our esteemed guest, Advocate Shirin Khajuria, ma'am. Over to you,
Thank you.
Jia.
Thank you, Pal, ma'am. Indeed, a pleasure to introduce Shirin, ma'am, Senior Advocate, Supreme Court of India. Miss Shirin Khajuria, ma'am, has the honor of being designated as a senior advocate by the Supreme Court of India. She has a diverse and rich experience of 35 years at the bar, including taxation, consumer disputes, arbitrations, environmental law, telecom and broadcasting, and criminal laws. She is a standing counsel for the state of Goa and Uttarakhand Power Corporation and was on panel on Union of India. As a legal officer at Sri Ram Food Fertilizer Limited, at the start of her career, she gathered valuable insights into the working of a company and as a law officer at United Nations Compensation Commission, Geneva. She gained experience in international dispute resolution. She holds a bachelor degree in commerce and degree in law from the Delhi University. Ms. Khajuria ma'am believes strongly in resolving conflict through mediation, a powerful tool for a self-determination and peace. She is a co-founder trustee of Nivaran Mediator of Supreme Court of India, which has been organizing annually international summer schools on mediation, besides other advocacy and educative programs on mediation. She is also an arbitrator with the Indian Council of Arbitration. Ma'am, we are very grateful to have you here. And over to our warrior, Miss Shirin Khajuria, ma'am.
Thank you so much, Dr. Jia. And thank you so much, Dr. Mayuri Pandya, for having me over here today. It's such a pleasure to join you as you celebrate 75 years of the Constitution of India. Thank you. So, as you would possibly know about the case, the direction that was given by the Supreme Court was that all the high courts were required to set up vulnerable witness deposition centers. So, we all understand what vulnerable witnesses are to an extent. We kind of think of them as people who may be children, who are below 18 years and who might find it difficult to address and appear before the regular court. Now, in this matter, I would just, before I really come to the facts of the case, if I could just, emphasize on the importance of witnesses. We all know that a case is based upon evidence in the Indian legal system, and the evidence would be as good as the witness. So it's very important to have good witnesses, evidence. Quoting Jeremy Bentham, witnesses are the eyes and ears of justice, and they are our silent heroes advocating for justice. So, let me just give you a little background as to the facts of the case. So, this was a case where a 14-year-old girl who was mentally challenged and also deaf and dumb had been raped by a neighbor. She had narrated the incident to her mother by gestures. There was also medical evidence which had confirmed that the rape had existed. So, the trial court, based on that, had convicted the accused, who was the neighbor. But the High Court set aside the conviction on the ground that the victim herself, who's the best witness, was not examined. And only on that ground, that the mother is more like a hearsay witness, the court set aside the conviction. In appeal, when the matter came up to the Supreme Court, the respondent, who had been the accused who had been let off, did not appear. In those circumstances, the court, to uphold the rule of law, appointed an amicus. The court was pleased to appoint me as an amicus in the matter. So when we were looking at the evidence, we realized that there may be more of a social legal aspect to it, as to why the child witness was not produced. It is possible that her parents thought that, considering her abilities and her mental state, she would not be able to withstand the court procedures, which are long, a little tedious, and also the cross examinations, which can be very hostile. Possibly, they also were aware of the fact that she would come face to face with the accused, which might scare her and permanently scar her psychologically. It's possible that because of these reasons, they did not produce her either before the police or as a witness. It is also possible that the police did not even realize that a deaf and dumb child who may be slightly mentally challenged can be a competent witness. It is also possible that the police did not know how to record such evidence, and that is why the child was not produced as a witness. Keeping that in mind, we did some research on the case law before that, and we found that for the last, in fact, 30 years, the courts had been pretty aware of the fact that they need to be more sensitive towards witnesses, especially the victims and witnesses regarding sexual assault. In fact, as far back as in 1996, in the case of State of Punjab versus Gurmeet Singh, the court had specifically said that the judges should be more sensitive to such witnesses who are vulnerable. They had also said that maybe direct questions should not be asked of them, and invariably there should be in camera proceedings. However, in camera proceedings, though the public, so to say, is not really there, but then the victim is faced with the accused. In the judgment, which came soon after that in 2004, in the case of Sakshi, in fact, the court realized that it may not really be good for the victim to be asked questions directly in cross examination. And so, what they suggested was that the questions be placed before the presiding officer. And the judge who was presiding is the one then who would convey it to the victim in a manner which she would understand and which would not humiliate her. The court in the case of Sakshi, in fact, also suggested, based upon international practice, that there should be a screen between the witness as well as the accused, so that she does not really fear the accused. Thereafter, when the matter came up in the state of Maharashtra versus Bandhu, where I was appointed, we realized that these are relevant aspects to be looked into. We dug in not only into legal case law, but we also delved in a little more into the other experiences of other countries. And we discovered that there was vulnerable witness deposition centers which were already existing in Delhi. There were two of them, one of them in Karkarduma and another one in the Saket district court. In fact, we visited the Saket district court to see the vulnerable witness deposition center, and it was quite an eye opener. Since I do not really do trial practice, so it was very interesting for me to see as to how this was completely different from the regular courtrooms that exist. One of the main aspects that they had in this special courtroom was that the entry was not from the main court premises. There was a separate entry at the back. And there were two different entries, one for the victim and another one for the accused. So there was no stage at which the victim faced the accused. So one of the primary reasons for fear of the victim deposing freely and accurately is because as soon as they say they're perpetrator of the crime, they are a little concerned about the repercussions of it, or they are mentally disturbed, and so they are unable to give the best evidence. So that was an interesting aspect that they had kept in mind, having completely separate entrances. They also had a separate, very comfortable room for waiting for the witnesses. It was more like a drawing room that you would have. And in fact, for children, they had a lot of toys around. The second aspect which was there was they had a separate room for giving evidence by the accused as well as by the witness. So the room in which the judge was there is where the accused was there, but there was a screen between them, which was a dark screen. And there was a large display screen in both the rooms, where the witness was as well as where the accused was. The questions were placed by the advocate before the honorable judge, and the judge then put it to the child. So at no stage did the child interact at all with the accused or the accused's advocate. It was only through the judge that she interacted. Another very interesting aspect was that they had a support person throughout to take care of the needs of the child. So even before the matter was fixed for hearing, we were told that there was an NGO who had sent a support person to visit the child at his residence. This was the case which we saw was of a 4-year-old child witness. I did not really witness the proceedings, but we were told that the matter had just gotten over, and there had been a 4-year-old child who was a witness to a murder, who had been produced before the special deposition center. And this child was visited by the support person a few days in advance to tell him as to what was expected of him in the deposition to make him comfortable. They had, in fact, even brought him to the deposition center, showed him the entire area a day before the actual hearing was to take place. And the support person sat with him throughout in that second row. The other fact was that because there was that dark screen between the judge and the accused, the witness could not even see the accused person through the video which was connecting them. So there was a complete separation between the two of them. The child was obviously able to, I believe, depose in this friendly environment with the toys and all also which were kept there and all across the places. So this kind of got me thinking and made me, and we suggested to the Honorable Court that maybe all the trial courts and the district courts need to have vulnerable witness deposition centers for witnesses who may be differently abled, for witnesses who are young, for witnesses who may be sexually, who have been sexually assaulted, or have any other barriers which would deter them from speaking out completely and fully the facts of the case. And the Honorable Court was pleased to accept the suggestion in the case of State of Maharashtra versus Bandhu, and they directed all the high courts across the country to set up at least 2 such centers within 3 months. And they also said that it would be better that if each district trial court had such deposition centers. This case was in fact followed up a few years later in the case of Smruti Tukaram. It's again the state of Maharashtra, but it was Smruti Tukaram versus the state of Maharashtra in 2022. So the courts felt that further directions needed to be given to implement fully the directions in the case of the Bandhu matter. And the court, in fact, has expanded the definition of vulnerable witnesses. Earlier, the definition was only a child who is 18 years plus. There were certain guidelines which had been laid down by the Delhi High Court, which in fact were based on best practices internationally and also the UN model law on justices for child witnesses, justice deposition by child witnesses. So, keeping these in mind, in the case of Smruti Tukaram, the court expanded the definition to say that it would apply not only to criminal matters, but it would also apply to civil matters and across all jurisdictions, wherever the court felt that there was a person was a vulnerable witness, and it would be better for them to depose in these special centers. The other thing which the court did was it changed the definition of vulnerable witnesses. It included not only people who were 18 years old, but it was age neutral and gender neutral. So those were some of the major changes which were brought around by the judgment of Smruti Tukaram. They also directed that a special committee be set up in all the high courts, which would continuously monitor the establishment of vulnerable witness deposition centers. They also directed that the courts follow the guidelines which were laid down by the High Court of Delhi till they modified and made their own guidelines. So it's been interesting to see as to what the journey has been of the court since then. I would like to just read out to you a paragraph from the judgment in the case of Smruti Tukaram. If I could just do that. It sets out very well as to why we have the need for such vulnerable witness deposition centers. The fairness of the process of trial, as well as the pursuit of substantive justice, are determined in a significant manner by the manner in which the statements of vulnerable witnesses are recorded. The dignity of a person, which is an intrinsic element of Article 21 of our Constitution, cannot be left to the vagaries of insensitive procedures and a hostile environment. Access to justice mandates that positive steps have to be adopted to create a barrier free environment. These barriers are not only those which exist within the physical spaces of conventional courts, but those which operate on the minds and personalities of vulnerable witnesses. There is a pressing need to facilitate the creation of an environment where depositions can be recorded freely without constraining limitations, which may be both physical and emotional. This requires not just the creation of an infrastructure, but sensitizing all stakeholders. The journey does not really end here. During discussions and, in fact, while visiting, the trial courts, I have found that the stakeholders, including advocates and the parties, as well as the learned judges, do not really know about these deposition centers or the scope of these deposition centers. It is primarily thought of as in-camera proceedings. And they believe that if they hold proceedings in camera for these vulnerable witnesses, that is sufficient. But what I have found while discussing with, especially with NGOs and support persons who take them to these centers, they say that in camera proceedings, there is a huge fear of facing the perpetrator of the crime, which in fact prevents the witness from giving their best and complete with their evidence. And very often we will find that the perpetrator of the crime is in fact a neighbor of the witness. And so there is even more fear in their mind. So that is why it is essential to have something like the Vulnerable Witness Deposition Center. In fact, I would call such centers as a soft shield, because they support the witness and they also make them feel safe and secure. The need is actually to spread awareness about these. I have spoken with some of these ministries, of officers in the ministries of women and child development, and it's been quite surprising to find that a lot of them don't really know the scope of this or even know very much about the judgment. So I guess the awareness is needed for it. This will transform how the witnesses perceive the justice dispensation system and the legal scape. The best witnesses can give their best evidence, I believe, with the support of these soft shields. Thank you.
Thank you so much, ma'am. We are having few questions for
Yeah,
you from
sure.
the students with your permission.
Sure.
Yes, ma'am, there is a question from one of our students. He wants to know that uh, in cases involving social justice, often it is taken activist stance to promote broader reform. So, based on your experience, what reforms are still needed to ensure the justice?
So that's a very broad question, and it's a very valid question. One of the main things I find is very often we have judgments which are written down, like in the case of Bandhu or in the case of Smriti Tukaram. But the important thing is awareness about it and actually taking it to the stakeholders who are involved. And it's not just the lawyers and the judges who are the stakeholders in a matter like this, which pertains to social reforms. It's the public which is also involved in it. So we need to have the public be aware about it, and we need to spread awareness about it, which can only be by having conversations like we are having today, I believe. Besides, of course, the formal trainings which the court has directed should be held even in the matter of Bandhu. But it is awareness, maybe possibly having guidelines for them. Like even in, like I was just looking up somewhere, like in England, you have a guidebook for the prosecution, which says as to how should the prosecution, in fact, deal with a child witness. So, for every stakeholder, you need to have such guidebooks if you are really wanting to have social reforms. And just a judgment and merely laying it down is not enough. We need to follow it up and become half activists to really take it to a meaningful conclusion. Yeah, does that answer your question?
Ma'am, thank you. The another question, it reads that State of Maharashtra versus Bandhu played a pivotal role in shaping India's criminal jurisprudence. But what were the most formidable legal challenges you faced while arguing this particular case, and how did you strategically address them? Students are curious
Right.
to know about it.
So, in fact, the most interesting thing was that, I was called in as an amicus because the respondent who was the accused was not really there. So I was in a bit of a fix as to whether I was supposed to be really defending the respondent or just being objective with the court. So I think that was the toughest balance for me to maintain because, frankly speaking, this was a case where I definitely believed, that it was a grave offense and this person should have been convicted. And yet, since he was not appearing, and the rule of law requires that he be represented, I had to strike a fine balance between representing him, speaking for him, and yet having a neutral voice. And that is where this suggestion helped me, because then one could look at it for future cases.
Okay, thank you for answering that question, ma'am. One more question. Uh, it is about, yes, the case has profound implications for the rights of marginalized communities. Based on your experience, what reforms are still needed to ensure the equitable access to justice for such communities? If you can throw some light on that, ma'am.
One of the things which I can think of is what I had said, even earlier, is advocacy. You need to let all the stakeholders be aware of the implications of it and as to how the marginalized communities, like for something like this, the matter originated from a small village. So I could well understand as to how the parents would have been hesitant about it. So as Naina was saying in her talk just before that, she said for us as lawyers, we need to be first empathetic. There's no point in practicing law if you do not understand the concept of empathy, and especially in making social changes. And law, when we are practicing law, it's frankly about making social changes. So if we don't have that empathy towards the marginalized communities or even otherwise, it would be difficult. And the only way to do it is advocacy, speak more about it. Like what we are doing even for mediation, we just keep holding talks about it as to what is mediation, explaining as to what it is about. The same way for this, we talk about what is BWDC, what are the difficulties which such witnesses might face. So yes, and I think the judges are possibly one of the crucial role players in this, because it can work downwards rather than going from upwards. So yes, it percolates downwards. Yeah.
Okay, thank you so much, ma'am. The last question for today, with your kind consent.
Yeah, sure.
I think just like what you and Naina ma'am rightly said, that it has to be empathy and empathetical approach is very much necessary. It is on that line only. The question says that many aspiring litigators are keen on engaging with PIL, that is public interest litigation, and social justice advocacy. What essential skills and perspectives should they develop to make a meaningful impact on this field, along with empathy that you already mentioned, ma'am?
I think you just need to keep your eyes and ears open and be rooted to the ground, be in touch at the grassroots levels, talk to people, to the common man. Maybe you talk to the auto man, you talk to your maids at home. It's just keeping your eyes and ears open. I think that also helps you develop that empathy, because empathy is not just a word, it's something which comes from within you. And that is something which you have to work with only if you keep your eyes and ears open. And grounded. Stay grounded. Yeah.
Thank you so much, ma'am, for shedding light over the case and over many other aspects through the answers that you have given for the questions of the students. I would like to request Dr. Urvashi Sharma to propose vote of thanks to our esteemed guest, Ms. Shirin Khajuria ji. Over to you, Urvashi,
Thank
ma'am.
you.
Good afternoon, everyone. It is rightly said that justice will not be served until those who are unaffected are as outraged as those who are. With this line, Ma'am, I extend my sincere appreciation for your enlightening presence at today's session. Ma'am, your dedication towards social justice, exemplified by your remarkable contribution in state of Maharashtra versus Bandhu case, has significantly strengthened the fight for dignity and fair treatment for vulnerable witnesses. Your presence at Stories of Warriors of Justice has been truly impactful, and we are grateful for your time and sharing your knowledge. On behalf of everyone here, thank you for your invaluable contribution to the legal fraternity as well as today's discussion. Thank you, ma'am.
Thank you so much. It was a pleasure
Thank
being
you.
here. Thank you, all
Thank you,
of
ma'am.
you. Thank you.
We request Aparna ma'am, can you please start your camera, ma'am? Thank you so much, ma'am. I request Dr. Jia Matharani to introduce our esteemed guest, Ms. Aparna Bhat. Over to you, Jia ma'am.
Thank you, Pal ma'am. It is an honor, true honor, to introduce Aparna Bhat ma'am, a senior advocate with over 32 years of legal expertise. Her excellence as litigator, policy developer, and legal researcher, she has represented the Government of India, private institution, individuals lacking legal access, arguing landmark cases in the Supreme Court and High Court of Delhi. Her legal intervention have reformed laws on acid attack, trafficking, and child protection, while her work as curiae has shaped judicial response to child abuse. She played a key role in establishing the rape crisis cell, increasing conviction rates in Delhi, and creating a specialized agency for trafficking cases. Aparna ma'am has developed national policies on child care, workplace sexual harassment, and victim rehabilitation, drafting amendments to key laws, and the designing legal framework like a rape victim relief and rehabilitation schemes. As a researcher, she has conducted in depth studies on juvenile justice, sexual exploitation, and the SAC Convention on Trafficking, influencing both national and international legal standards. She has contributed to prosecutor training manuals, advised the government on gender policies, and played a key role in setting up India's first vulnerable witness courtroom at uh, Kanakadoma Courts, Delhi. Her extensive work in litigation, policy, and institution reforms continues to drive transformative legal change, ensuring justice for marginalized communities and strengthening the protection for women and children. Ma'am, over to you.
Thank you so much. It's such a pleasure. I have to appreciate the persistence of the college and Dr. Urvashi Sharma, Dr. Pandya, Jia for introducing me. Yeah, thank you so much. And it was actually after Shirin's and Naina's intervention, there's very little I can add. But I'll try my best. And I agree with Naina. I was hearing her. It's always better to have a physical interaction. We would like to see the students and talk to them. It's really much better. Okay. My brief today is to talk about my journey in Lakshmi's case. Now, Lakshmi, of course, many of you may have seen her now. She's become a celebrity, a motivational speaker, and she's really evolved from what she used to be to what she's become now. It's a pleasure for me to see her. Speaking about the case, uh, I'll just tell you a few things before. You see, Lakshmi, at the time I met her, and that case had already started. She was already attacked, and she had undergone about two surgeries by the time I met her. And one thing, this is a personal thing I'm sharing, it's not as a lawyer. Of course, I met her at a common friend's place, who was like the friend was helping her. So that's when I met her. The first time I saw Lakshmi was when my friend called her to the room to introduce her to me. And I can't get over the sight till today. I mean, I knew that people have been attacked. I've done all kinds of cases, represented people who've been very seriously violated. And so I had thought that I never thought that I will have a personal, how to say, experience of that I met Lakshmi. It was fear and it was shock that something like this can happen to a human being. And if you can imagine, if that's what I felt just by seeing her, what she would have felt when the injury happened to her. I don't think there are words in any language to express that pain she must have gone through, the shock, the subsequent whatever that's happened to her. So it's kind of when anyway. But on the other hand, what struck me also was she was not completely desolated. She was not talking about any negativity. She was a very young person. I think she was 16 at that time. So she was able to sit with me and have a very calm conversation about what I was telling her that I can do with her. With her, together with her, what we can do. So this was my first meeting. I was and still am very impressed with Lakshmi as a person. And anyway, coming back to the case, so at the time when I met her, what we had known, they knew barely about the case. One thing I just would like to tell the students is that, and I'm sure if your people have interned, you already know about it, is that our criminal justice system is designed in a way, not just here, in most common law jurisdictions, is designed in a way where the case is tried by the state, the police. So, as a complainant, the person who is actually a victim of the crime, I'm using the word victim loosely here, the person who has been violated by the crime or their families, they are just witnesses in the police case. So, in the scheme of things, for a very long time, they had little or no role except to show up in the court when the court called them and to give their evidence. And so that's how it was. So, while Lakshmi was the person who had suffered the crime and she was so seriously violated, but at the time I met her, she had a copy of the FIR and perhaps very sketchy information about what had happened to her, which the policeman had told her. That's all she knew. They didn't know. We had to find out everything. And the criminal justice system, then and even now, doesn't really give a serious role for the lawyer of the victim because you're supposed to only assist the prosecutor, even if you think the prosecutor is not doing the job properly, or even if you think the prosecutor is not competent. Sometimes, many times, the people do feel that no, he's not competent, he's not doing our job properly. We want this is too serious a case. The other side has got lawyers who are way more qualified. They have better infrastructure and resources. Even then, the system doesn't allow anyone for any of us to actually uh, support or participate in a way as as an equal participant, as an equal stakeholder in the case. This is how the criminal justice system is. So anyway, so we tried to find out what's happening. We met the police. Luckily for us, this was a case where the police was completely cooperating with us. They were with us together. A senior police officer had shaken a lot of interest earlier, and they had managed to arrest everybody. So the charges were framed. Of course, there are a few loopholes. One you can find as a lawyer when you implement, but more or less, the case was quite well prepared by the police. And then when we got around to the first thing that I noticed within a few days is that there were three accused in the case. The person who attacked her, that was a woman. The person who was driving the bike, and the woman's boyfriend, who was this guy's brother. So there were three accused in the case. So the brother was, I mean, hardcore criminal, is what they say. He had so many cases against him in various places. He was already in prison for some other case. As far as Naim is the person who was riding the bike, at whose instance everything happened. He was out on bail on the ground that he had some wedding to attend. He got bail immediately. Within a few months, he got bail. The person who was in the jail was the woman who attacked her. So when we intervened for the first time, when I saw how casually the bail was given, what struck me was that in the court, in the pleadings, in the presentation of the papers by the police, which had the FIR and a few other things, the gravity of the offense was not visible. It was written acid violence, but then it was not a visual that the court judge had, and he took it as okay, another attempt to murder, and very casually, the bail was granted to the accused. And the second thing was also that when the first time when the woman filed for bail, at the time I was involved, and I actually went to the court. Even then, he was almost granting bail. That's how I remember. I mean, many years back, our memory goes a little here and there. So, but anyway, we were able to intervene, and they said we would like to reply to the application for bail. Even the prosecutor was not opposing. So then I decided, and I looked at it, and there was very little jurisprudence on acid violence at that time of any high court or any Supreme Court that we can use to oppose the bail. And most of the Lakshmi's case was also tried as an attempt to murder. In an attempt to murder case, granting of bail, and the ground this woman was using was that she happens to have a child and she's in the prison, the child is by herself, and those kind of grounds, which any court would have actually given her. And the co-accused had got bail. Those two men had got bail. So any court would have granted bail to her. So we were kind of abusing, and I actually thought, let the judge see Lakshmi, let him see what happened. And I encouraged Lakshmi to come to court. Lakshmi was at that time not keen to come to court. She'd heard all kinds of things. So we encouraged her. We said, come to court. You see what's happening, participate in the proceedings, so you'll know exactly what's happening because you are such a key stakeholder here. So she came to court, and the judge saw her. And I think that kind of turned tables. That completely changed everything. And the judge did, and that girl never got bail throughout the trial because the trial, of course, then started getting faster. The dates were given faster. That's when I thought to myself that, the judges should know that is it acid violence. And judges should know acid violence can impact a person permanently in a way you can't even imagine and also cause so much pain that you can't imagine. So there was some, and how will they know that unless it is communicated to them? And we thought the most effective communication is that we should have a provision in the law which recognizes acid violence separately and not include the grievous hurt or in Lakshmi's case they had made an attempt to murder. So these two cases, so we wanted to make sure that these two cases don't happen. So this was the first thing that we did. And the second thing that the trial was going on, the trial went on, and of course, Lakshmi gave her evidence, and then I'll now come to the PIL, which we filed, and speak to about 5 minutes before I wind up. So the idea of PIL was there. So people were working, and as a person who worked with women and other people, I had an idea that people are already working on acid violence, and acid violence cases are increasing in the country. I was aware of that. But I was not sure to the impact of it, and I'm also not sure what they were doing. So I was going around asking people, travel to Bangalore where the work on acid violence was more in compared to other places. So when I did all that, I found out that yes, people had done some work and they were planning to file a petition. And their line of thinking and my line of thinking was similar, except that we had some different opinion on a few things. Anyway, so then, but there was no case to my knowledge at that time. It was filed. So we also found that Lakshmi, then by that time we were talking to her benefactor, Shirin, who supported her in this entire journey of treatment and other support that she gave her. We decided that government hospital where Lakshmi was getting treated was not the most appropriate for various reasons. So of course, one thing was to go to court and ask that the government hospitals are better equipped and other things. So this was one of the things that were one of the plans we had. And Lakshmi then got shifted to a government hospital, to a private hospital for plastic surgery. And of course, Lakshmi had the advantage of a financial support given by somebody. One person was giving her financial support. So she was able to get the treatment. So we thought, how many people will be able to get this treatment? And also, what about compensation? Let's say even if people get free treatment, what happens? And there are so many other expenses that people incur. one family member has to be like almost like an attendant with this person. Then, so that person will have loss of wages. Then what happens at that time? There's multiple things that we were looking at. So this was one big factor in the PIL, which we thought of healthcare, or kind of healthcare that can be given to her. The third thing, which was that fact is why is assets so easily available? It's such a dangerous thing. It's so potent. It can harm people permanently. Call first, and when you luckily had eyesight, her eyes, she didn't lose her eyesight. But I had dealt with over the period. I dealt with victim people. Some people had completely got blinded by it, and such a potent thing, and it's available so easily. For 100 rupees, you can buy a bottle of concentrated sulfuric acid or nitric acid, hydrochloric acid. All these are the main three things that are available so easily. And on the so we thought, okay, this is another acid should not be available so easily. So that's how the genesis of PIL happened. A new law, acid availability, and compensation. So this is on broad three lines that we had gone to the Supreme Court. The journey in Supreme Court, unfortunately, was not as smooth as I thought it would be. In fact, the first hearing, of course, was went very well. They called in, but then the case took almost 2 years to be taken up second time for hearing. And thereafter, you'll be surprised that the government of India opposed my prayer. They said that there is no need. We already have a compensation scheme, and as it is needed for everything, we can't ban it. It's very difficult to ban, and we have grievous hurt in our penal code. That's good enough. So that was the government's first affidavit. So it took many years, and finally I had so major strategies that I had to make. One, I filed the Bangladeshi law. Because if Bangladesh has a law, if Bangladesh can have a law, why can't we have? And then there was an instance where I'm part of research, and when I was doing research, I found that in Rishikesh, a place like Rishikesh, they had banned sale of eggs. Now we said eggs is something that people consume. If you can manage something like that, why can't you manage acid sale? There's something. That's another thing that which we use. And I'd also found that one of the presidents of the U.S. was visiting in India for a few days. So at that time, the time preceding his visit and time after, during some period of time, acid sale is actually banned in Delhi. So we use those examples. They said that if you are able to do it for this period of time in this manner, why can't you do it on a long-term basis? So these are some of the challenges that we had. Anyway, finally, the first thing which happened was the CRPC was being amended, and the penal code was they were looking at sexual violence law. This is nothing to do with Nirbhaya, I must say, because everybody thinks because of Nirbhaya this came. This has nothing to do with Nirbhaya. The government actually acceded to our request that okay, they'll change the law because in many hearings the court got very angry with them. The attorney general was called, and lots of things had happened. I don't think I have the time to go through those individual hearings. But the amendment to the law was agreed to by the government, and they introduced these two sections, 326A and 326. Indeed, they introduced those two sections. And but unfortunately, there were two terms in the parliament because opposition had some issues. The entire session couldn't take place. The parliament for one full or two sessions did not happen. So soon, I mean, after that, so we were the sections were ready, but since the parliament was not sitting, and there were no effective sittings happening in parliament, this law was kept in, nothing was happening. So kind of in cold storage. So finally, the unfortunate incident of Nirbhaya happened. Then soon after Nirbhaya incident happened, the government of India brought in an ordinance in the criminal law, and they changed the criminal amendment. And I must tell you this, although Justice Verma Commission has done a fantastic, phenomenal job, but the acid violence law and even the changes we made in penal code that was already in the pipeline for many years, and somehow the government uses opportunity bring this law into an ordinance. So this law came out. The only thing that we all welcomed was the section of trafficking 370, which got introduced in along with this. Otherwise, all other laws were already in the pipeline for many years, and they got passed at that time. So the law changed. Subsequently, the ordinance then became the law. That law changed, and acid balance law is there till today. This is separate section now for acid balance. There's also compensation if there's deaths and other things are there. Now, with respect to compensation, the court saw the way, and now while this case was going on, another very serious incident happened in Bombay, in the Bombay very busy railway station. A girl had gone from Delhi to give her nursing test, and then she was thrown acid over there by an unknown person. And for then nobody knew why that person, who that guy was, and this girl unfortunately passed away. So that kind of triggered. I made an application report saying this is what is happening. You're not doing anything about it. Government is doing nothing about it, and people are, young women are targeted more and more, and people are dying. And this girl died, and that kind of triggered a huge thing from the court. The court asked the government to do something, and then by the time this law had come, and then they also talked about now acid sale regulation. So they directed me to sit with the Solicitor General and the official Ministry of Home, and we had sat across, and then we discussed the law. I had wanted it to be taken as a dangerous arm, so I wanted it on that category, but they didn't agree. So they put it under a poison, and then they made some regulations, and the regulations came. So basically, although we wanted a ban, what we got was regulation. Have to say that it is not implemented the way it ought to be. And I think it's for people like you, the students, to take this further. We please understand that whether it's a case which Shirin talked about and Naina talked about, which I talked about, PIL will bring in some results at the macro level, but for it to get benefited at the micro level, a lot of advocacy is required. And as individual lawyers, I don't think we have the capacity to do that kind of advocacy. The advocacy can come as if we, as a community, as a collectively, we come together and do it. I'll find up by saying the last thing which came up in acid violence in this case also. You see, so we were looking that the court also directed that there should be a minimum compensation of 3 lakhs. 3 lakhs should be the minimum. They can be maximum, but this should be the minimum compensation and should be given within 15 days because they should not be made to go around in circles because they need the money immediately. That's the third thing which happened. The fourth thing which happened, which unfortunately again is not being used by people at all, maybe due to lack of awareness, is that the order also said that private hospitals should also be willing to give free treatment for acid victims, which includes plastic surgery. And so they said that if they want to do it, they gave them liberty to use their CSR fund. If they want to do that, they can do it, but then they should be giving it. So the four things which happened. It took over 10 or 11 years, I think 10 years it took for this case to finally conclude. Uh, the courts was always sympathetic, but in spite of that, the case went on such a long time. The government, unfortunately, was opposing it for absolutely no reason, and this is not a particular political leaning I'm talking about. Everybody but somehow didn't want to do as much as they needed to do, and then finally they came around, and you have these in front of you. Yeah. So I want to stop now. If there are any questions, I'll be happy to answer. Thank you.
Thank you, ma'am. We definitely have some questions from the students, which I would really request you to answer them. Uh, the first question is, how effective have the legal measures from Laxmi versus Union of India been in reducing acid attacks? And what further reforms do you suggest? Ma'am, this is a question from one of our students. If you could please answer this question.
Yeah, thank you. As I was saying, yeah, I was saying this. We do these cases at Supreme Court. It's at a macro level. I'm not sure how effective the legal measures have helped. I hope they have helped. And it is for students like you to take it up further, at least in your own area. Why don't you, as an activity, for example, it can be a legal aid activity. I'm sure the colleges have these kind of clinics, that paralegal activity, that paralegal support services that you provide for. Why don't you actually do a survey and check if acid is available? Because this for an effective implementation, we have to have very effective advocacy, and advocacy has to start from all of us together. It can't be one person's job. I'm sitting in Delhi arguing this Supreme Court. I will not know what's happening within Delhi itself. So, in terms of how effective legal measures for Lakshmi in India, I mean, for a Union of India case has happened, I would urge you to check in your neighborhood, and maybe when we meet next time, we will have some information about what has happened. The reforms I suggest is for the entire community to get involved. to make sure that with these kind of problems, an acid sale is not so easy as it used to be. I'm actually throwing the challenge at you back.
Yes, ma'am. Thank you for the answer, and indeed, it's an amazing answer. So it's true that we ourselves need to understand whether no there are any remedies or reforms being taken up to deal with such kind of cases. Thank you, ma'am. We have one more question put up by our student. The question is, what advice would you give to young lawyers who want to work in public interest litigation and fight for social justice?
Yeah, I mean, it's a nice question, and it's always a pleasure to talk to students who think like that. You see, yeah, I would, if you want to pursue human rights law is as competitive and as how challenging as any other field of law. My advice would be first, you need to actually excel as a lawyer. It doesn't matter what stream you take. So excel in your research, excel in your drafting, excel in your court appearances. You need to do that, and then look at any case and do two things. One, thoroughly research the subject. Look at parallel jurisprudence. Suppose you're fighting a case in India, look at what's happening in Bangladesh, look at what's happening in Pakistan, look at what's happening in Indonesia, Philippines, similar culture, similar jurisdictions, and see what's happening there. Get some information about what's happening in the US, for example, or Australia or Canada, England, in Europe. You do your research thoroughly. Then make sure you draft the petition properly. And as far as the practical part is concerned, this is challenging. Obviously, the commercial law remuneration may be way more, but there is certain satisfaction you get. And please remember, when you do human rights cases, you are supporting the section of people who cannot access the court had it not been for you. It's a huge responsibility, and I would also think it's a huge privilege. Even though you don't need full time human rights practice, even if you take up one human rights case a day, you are contributing to the law and the community in a way that you can't even imagine. I would urge all of you. I'll be more than happy to mentor any one of you at any point in time. And mentor is, of course, a very large word, but in any way one is possible. I think I would encourage you to pursue human rights.
Thank you so much, ma'am, for your kind words. Definitely, we would seek your help. As you already said, that whenever students need, you would like to help them out regarding this. There is one more question that we would like to ask you, ma'am. Uh, it is from one of our students who wants to know that legal case or victories are only one aspect of systematic change. How can legal community work with civil society and policymakers to ensure that judicial pronouncements bring tangible social impact in your views?
This is similar to the first answer I had given. We can't work in silos. Just if you want to do a social change, you have to also involve all other stakeholders. For example, if you want to do a policy change, it's important to engage with policymakers. And if you want to do working in the community, it's important to work with the community. You see, a human rights case can become effective only if the ultimate beneficiary feels that he or she is affected in a positive way, impacted in a positive way, right? Otherwise, these orders remain on paper. If the acid violence case judgments have come and they remain on paper, I will have the satisfaction that I conducted a case and I'll come and talk to you, in lectures. But in terms of actual translation to any advantage to a victim, there is none. So it's important that we engage with the community in a very effective way. Yeah, that will be my answer.
Thank you, ma'am. Again, this could be the last question. You have already answered this, but if anything more can be add on for this, ma'am. Last question for this: how can the legal system ensure that the voices of acid attack victims are heard and considered throughout the judicial process?
Yeah, I think there is a amendment in the criminal procedure code now. You can apply to the court to have a lawyer appointed. And I think do access legal aid and please do advocacy in the community to tell people, it's not just for acid violence, all other victims of crime should be told that they can access legal aid. Not only that they can access legal aid, they should be advised that they should access legal aid so that their rights are also addressed in the entire process.
Thank you so much, ma'am, for answering all the questions and queries from students and budding lawyers. I request Dr. Urvashi Sharma to propose official vote of thanks to our esteemed guest. Over to you, Urvashi, ma'am.
Thank you, Payal ma'am. Today, we have witnessed stories that serve resilience and determination. As we conclude another chapter of Samvidhan Safar, I feel privileged to extend my gratitude towards all. A sincere gratitude to Ms. Aparna Bhat, ma'am. Ma'am, your role in Laxmi versus Union of India has been instrumental in strengthening protections for acid attack survivors, ensuring stricter regulations on acid sale, and advocating for dignity and rehabilitation of victims. Thank you so much, ma'am, for your presence and a motivating session. A heartfelt thank to our all other esteemed speakers as well, Ms. Naina Kapur ma'am, Ms. Shirin Khajuria ma'am, and Ms. Aparna Bhat for sharing experience and words of inspiration. Your work continues to pave the way for more and just equitable society. A sincere thank to our esteemed Dean, Dr. Mayuri Pandya, for her constant encouragement and inspiring leadership. This event is not just a dialogue, but also a movement towards change, awareness, and legal empowerment. Thank you once again, all of you, and we look forward for many more such enlightening sessions and conversations and future. Thank you.
Thank you, everyone. With that note, we are ending our session here.